Ready? 3, 2, 1, start. It is alleged that the appellant formed a company which was more in the nature of a partnership. This company's bank account was used to directly or indirectly collect the funds from legitimate or illegitimate sources for the use of several activities. Deputy Commissioner Ranchi sought sanction to prosecute, which was granted by the Principal Secretary, Department of Home, Prisons and Disaster Management. However, subsequently, the Ministry of Home Affairs, Government of India, issued a transfer order. Supplementary charge sheet was filed by NIA, wherein the appellant was named as a witness for the prosecution. It is in this backdrop that the judgment impugned was passed. Whether the central government has got suo motu power to transfer the investigation to the NIA once the investigation has been completed by the police. There is no lack of jurisdiction on the part of NIA to carry out further investigation and submit the supplementary report. The second issue concerned the legality and propriety of sanction, which was challenged on the ground that Rule 3 was not followed. The timeline stipulated in Rule 3 has been strictly followed. The third issue is as to whether the cognizance order is afflicted by non-application of mind. The court considered the judgment named State of Gujarat versus Afroz Muhammad Hassan Fattah to examine the power of the magistrate at the stage of issuing process or summons. It was finally concluded that the approach of the special judge requires no interference. It is contended that the sanction order was passed mechanically without supplying any reason or application of the mind. The orders are stereotype and standard. It is submitted that Section 45 requires independent scrutiny and application of mind at each stage. Validity of sanction is a question that can be raised at any stage of the proceedings. There are instances of this court setting aside conviction after completion of trial and even quashing entire proceedings upon the filing of bail application before trial on the ground of invalidity of sanction. In furtherance of this submission, various judgments have been referred, such as Ashraf Khan versus State of Gujarat versus Anwar Khan Osman, and Jamiruddin Ansari versus CBI. Both the authorities have not considered that mens rea is absent, which is a requisite to constitute a criminal offense. Reference is made to the case of Sanjay Dutt versus CBI. In referring to latter judgment, reliance is placed on the holding that if a reasonable interpretation is there, then courts are bound to take that approach. The appellant was not made an accused in the first module nor in the second module, and sanction in respect thereof was granted by central government. Appellant contends that he has wrongly been implicated into the proceedings even when he is a laborer. He is illiterate and does not understand business transactions. Accused took undue advantage of his situation and stole his identity. He is relative of Dinesh Gope. NIA recommended prosecution of the accused persons, including the present appellant. The impugned sanction order has been passed considering all the relevant materials on record, including the recommendation of the authority. Merely because the sanction was granted within 1 day of the recommendation, it cannot be said that there was non-application of mind. The appellant is an active member of a terrorist gang and a close associate of Dinesh Gope, who is accused number 6. The claim of the appellant is unsustainable and quashing cannot be placed on such a vague plea. The trial is at a very advanced stage, and as such, no discretion be exercised in quashing the criminal proceedings. Hence, we proceed to decide the issue on merits. Stop. E 123 पे